the record, ma'am. Do you not? Okay, thank you.
Hello, hello, hello. It's Attorney Mark Irvin coming to you from Chicago as usual. Yes, I'm back in Chicago and I feel it. Here I am. Big shout out to Law Nerds Unite. Zach hooked me up with material because I had a travel day. Like, I have a lot of material. I don't know how far we'll get. There's a long one at the end. I don't know. I did a video about this Stalker a while back. I don't know. It's long, but it's interesting. And then Zach got extra material. It looks pretty good. I don't know. I'm back here where the Wi-Fi usually works. I mean, you know, now that it's over, I'll tell you. I was in New York. It's a nice town. I don't think they have issues with Wi-Fi. But I did. Mostly not, though. Mostly it worked, but then it would just decide it doesn't want to work anymore. Don't worry. I had flamingos dragging me up and down the streets of Soho and Fifth Avenue until they pushed me to a point where I left them with my credit card and went back to the hotel. Yes, I did. which is, let's face it, what everybody was looking for. But enough about me. Let's get into this. We got some crazy stuff. I think the first one's a Karen. Let's do it.
Good morning, Your Honor.
Okay.
Looks like we have one ready for you.
All right. Which one? You or Mr. Gwynn?
Mr. Gwynn.
All right. Which one do you have, Mr. Gwynn?
Yes, Judge. This is going to be 318,015-E, Krauskopf.
All right. Just a second. Got it right here. At this time, the court's going on the record, and this is Bell County cause number 318,015. I'm sorry, 015E. And
we did
this is
indeed.
the interest of Krauskopf. I'm probably mispronouncing that, but I'll get the correct pronunciation in a moment. Krauskopf minor child, non-custodial party being Joseph Ryan Krauskopf, custodial party being Mary Catherine Owens. And this matters before the court on a super modification of child support and motion to confirm arrears. Court's taking judicial notice of the court file, note for the record in this matter. That the child in this matter looks like just turned 9, looks like. So well of the age of 18. The court will note that both parties were served last year, one in August and one in September. So both parties are properly before the court this time. And so I'll ask the state for an opening to tell the court what the state's requesting we do here today and what you understand agreements and contests to be and what you expect the testimony to show. Thank you.
Thank you, Judge. The state is asking for a modification of child and medical support, as well as a confirmation of arrearages, if there are any. Basically, we are looking to confirm arrears at the end of the month prior to the start of this modification and set appropriate repayment for arrears, if any. Child support arrears as of September 30th, 2024 are currently show is $39 with an appropriate repayment of $5 per month. And then the medical support arrears as of the same date are $273.40 with an appropriate repayment of $56.
What the hell is this? $39? Is this 1963? What's going on here? I don't get it. I don't know. But I will say that it looks like it has potential.
Per month, either of which could be covered by a lump sum by a date the court provides, if the court prefers. The testimony will show the child is currently on government medical. The parents do not appear to be in agreement about this. The testimony will show that there is private medical available at a cost of less than 9% of the non-custodial parent's income. That number comes out to be $342.15. We are looking for a judgment on arrears as of the 30th of September 2024. And the state has calculated that the child support would be modified to $897 if the child remains on government medical, and at $880 if the child were to receive private coverage.
All right, then. So this is a straight out dispute on support
Judge needs to hold this cat in contempt. I mean, seriously.
and possibly health insurance coverage.
That is correct, Judge.
All right, then, guys. All right, here's the deal, folks. The math's the math. Let's figure out what we got here, and the court will. If someone's asking for something different than guidelines, then the court will. That falls on them to show the court why that's necessary and why it's in the best interest of the child. And the other item is I'll have the state ask specific questions about the health insurance circumstance. My understanding is that there's government insurance involved, and as long as the child is on that, the court can either set it up as a repayment or ask order dad to go ahead and get health insurance. But mom is obviously able to keep that health insurance if that's what she has, if it's Medicaid, and the court won't order reimbursement and let dad's insurance be secondary. But there are options under that circumstance. So at this time, I'm gonna go ahead and get some testimony, and let's see what the differences are at this point. So at this time, I'll ask both parties to raise your right hands, please. And ma'am, you need to unmute yourself.
Sorry.
No problem. Do you both solemnly swear or affirm any testimony you're going to give here today is the truth, the whole truth, and nothing but the truth will help you?
Yes.
All right. You're both officially under oath, and I'm going to let the state call you both as individual witnesses. At the end of the hearing, if there's anything either of you think I need to know that didn't come out in the testimony from the questioning of the state, I'll allow you to tell the court that information so long as it's relevant, and we'll get that taken care of because technically you represent yourself. So if there's something that the state missed, you can tell the court that information. So you may.
I'm thinking the same thing. Is this a couple or am I missing something? Oh, she's already got her hand up. She's already got her hand up. All right, let's see.
Proceed at this time, Mr. Gwynn. Thank you.
The state would like to call Mary Owens.
Yes.
Ma'am, state your full name for the record, please.
Mary Catherine Owens.
All right, thank you. You may proceed, Mr. Gwynn.
And what is the name of the child that we are here on?
Braden Thomas Krauskoff.
Okay. And how old is Braden?
Yeah,
Braden just turned 9.
they're a couple.
February.
And are you requesting guideline child support?
I am.
Okay, and you understand the amounts that the state mentioned as
Joe's just got that look like I every day I look at this situation, I can't believe I did it.
to what the child support would be on either, depending on the medical coverage provided for the child.
Correct.
Okay, and you're in agreement with those numbers, correct? Okay, and how is the child currently receiving medical coverage?
I have him on Medicaid.
Okay, and do you have a preference as to the child's medical coverage?
I don't have a preference. What I have a concern with is that because he is a special needs child, there are certain providers that do not accept Medicaid, or they put you on a longer waiting list for it. And if it's possible to have a private insurance that would get pushed through quicker, that's what I would hope that he could have.
Okay. And you say that the child has some disability or special needs. What kind of special needs are those?
He's a nonverbal heart baby who has Down syndrome and autism.
Okay.
Oh,
so he's nonverbal.
Sensory disorders, eating disorders.
Okay.
Real quick, ma'am, the Medicaid the child has, he has that in his own right, or is that something that you got through the state separate and apart? Because it sounds like he had his own. This may be something he's getting based on his disabilities.
I applied for it. It's in his name, but I had to apply for it.
Okay, so is he getting SSI at all?
Yes.
Okay. Then Mr. Gwynn, I don't think cash medical is even appropriate on this one because, again, the child gets the benefits based on his own disability and not just being meet the criteria for Medicaid. So I'll be looking at getting some testimony from Dad on having him do the supplement. So but that's the way that needs to be set up, sir. Thank you.
Okay, thank you, Judge. And you were wanting to increase the support with a start date of the 1st of October of last year, 2024?
Correct. That was when I was eligible after the 3-year waiting period to modify child support.
Okay. No further questions for this witness at this time, Judge.
Why is she sticking her lips out? Like, like this. I don't get it. I don't get what the advantage of that would be. It's not enticing. That doesn't explain it.
Thank you very much, ma'am. I'll be back in just a moment. Call your next witness, please.
All right. State would like to call Joseph Krauskopf.
All right, sir. State your full name for the record.
Joseph Ryan Krauskopf.
All right, thank you. You may proceed, Mr. Gwen.
And Mr. Krauskopf, you understand the guideline child support is calculated by the state?
Yes, sir.
Okay, so you heard that in the opening. Now, you want to vary from that guideline child support, correct?
Yes, sir.
And why is that?
The way that I'm paid, I was asking for a compromised amount because I'm guaranteed 42,000 throughout the year as a base. I mean, that's my base pay throughout the year, and then at the end of the year, I'm paid on bonuses, and I do not know the amount of that every year. And I do know that we have to go back the last 2 years of what I made and do a calculation off of that. And I was asking for a compromised amount because I'm not paid this monthly throughout the year, the amount that is for the full year. So I was asking for a compromise amount of $600 a month, and then a lump sum at the end of the year of $3,564, which would be the calculations of the balance of what the difference would be and what the child support calculation is per month. I know that I'm liable for that. And going back to the arrears that you stated in the beginning, I wasn't aware that I had any.
Okay, sir, okay. Don't worry about that.
Okay.
That's a clerical thing. It comes. It depends on you paid and it came in. So when they tell me everything's
I got you.
a couple $100, then yeah, that's just the calendar working there. So not a problem, sir. Don't worry.
Okay, so these small amounts are just because he's paying, and he thinks he's paying the right amount, and he literally doesn't know. And here she is trying to get another $39 out of him. All right. That's it. That's not the amount of the child support. I get it.
Don't worry about it.
Yeah. So, I submitted the letter from my employer that showed that what I made throughout the year and the way that I'm paid. And then, and like I said, I would like to play a lump sum. I mean, it's hard for me to come up with that. I mean, what they're showing as far as numbers is $897 a month on child support, $259 on the Medicare reimbursement. So that's $1,156 a month.
Okay, sir. I'm getting ready to stop the Medicare reimbursement because it's the child gets Medicare and not Medicaid. Okay.
No, he gets Medicaid.
Okay, I'm sorry. It's Medicaid. I'm sorry. It's Medicaid, but yeah, I'm sorry. He's not a senior citizen, but he gets it based on his own disability, sir. So that's there's 2 types of Medicaid, and one of them is where low income Medicaid, and one is for people who are actually disabled, and your child's disability, he gets his Medicaid. So I'm looking at stopping the Medicaid amount, sir. Thank you.
Okay. So $897, and I like I said, I would like to do a compromise. I know I'm responsible for the rest of that at the end of the year. That allows me to save. So that's the only reason that I'm here is asking for that. And then I know we're talking about this issue right now, but then there's some issues with the visitation.
Okay, so right now, I'm sorry, sir. Right now, the only pleadings I have before the court are dealing with child support, sir. If there's a visitation issue or a visitation problem, that can't be brought up today because it wasn't officially noticed to Ms. Owens that there was a problem. So,
Okay. Yeah. And I got you. Okay. Yeah, and as far as medical records, I have not received any medical records when asked from her.
Yeah.
And I
Okay,
barely
ma'am,
got,
don't interrupt. Don't interrupt. Okay, it's okay. Again, sir. Go ahead. I'll let you finish. Thank you.
well, I mean, I'm just saying that just so
It's warming
you
up.
kind of know, I would like to cooperate with Chrissy because of Braden, and I get him on the first, third, fifth, every Thursday, like I should, summer visitation, all of that. I've been involved in his life, and as far as getting information from her, she's not cooperative. So,
Okay.
I'm sorry, Your Honor. Objection
Again,
has no relevance.
Okay.
Okay.
Again, sir. Here's the deal. All right. I'll do some things in my closing, but for right now, again, sir. Right now, I'm just looking at child support and
Okay.
how to set this up, and based on how you get paid and how often you get paid.
Yes, sir.
And how you get your money. So it's your testimony now that you get obviously you get a monthly amount, but you get an annual bonus, and you're asking the court to order a annual payment based on that bonus to go along with your regular child support instead of averaging it out over the whole 12 months. Is that correct, sir?
That is correct. Yes, sir.
All right, thank you. All right, any other questions of the witness, Mr. Gwynn?
First off, just to establish, there is private insurance that is available to you at a cost of or available for the child at a cost of I'm sorry, I lost my note. Of $342.15.
Sir, do you the question was to you, sir. Do you have health insurance available that
Yeah, as of when I checked in it on July through, if I go through my work, the last amount that I received from my work, unless it's increased this, then July was $342.15 a month. Would be what it would cost me to put him on my work insurance.
And also, as an aside to the court, the state would like to note that without a cash medical reimbursement, that would change the child support obligation for guideline to be $949 per month.
I'm definitely looking at ordering dad to go ahead and put the child on health insurance based on the testimony I heard from mom saying that there'd be something that she would like, and the fact that the child's on its own disability. So I probably am looking at dad. Ordering dad to go ahead and place the child on health insurance, and you don't have to wait for for open enrollment with a court order, sir. So I'll let the state I'll let you go along and ask some questions, Mr. Kroskoff, if he's okay with that, or if he has any questions about that. Thank you.
I'm sorry, could you repeat that last sentence, Judge? I'm not sure I heard you.
I'm sorry. All right, I'm looking at ordering dad to go ahead and maintain health insurance, and I'm looking at ordering him to do that from day one as part of this court order. So I need to, and so you need to work and see what the math is based on that, and see whether or not the father is in objection to it with any questions. Thank you.
All right.
All right, I'll ask you because that was kind of convoluted. Here's the deal, sir. Again, the child gets his own Medicaid based on his disability. As part of the child support order, it's your responsibility to also maintain health insurance. If you've got health insurance available to your employer, I'm looking at ordering you to pay. Go ahead and place your child on that health insurance, and it can act either as primary or secondary. However, Medicaid wants to handle it. Probably going to make Medicaid secondary and make you primary. That's the way the government works these days. I'm looking at going ahead and ordering that, sir. Is there a problem with that, sir? Do you have an objection to that? And if you do, what's your objection?
I mean, well, I mean, the objection is I don't know. He's not on. I don't see any medical records. I don't know that he's on any kind of medication, or I don't know anything about his therapy because there's no communication. And I know we're talking about just the money here today.
Okay, here's the
I don't know why he would need a secondary insurance,
well, I'm ordering it, sir. So
okay.
because it's part of your child support obligation, sir. So, and again, the taxpayers of the United States of America are taking care of your child for you. So yeah, you need to chip in. So I'm not trying to be facetious, sir, but
no, but has that not been taken out? I mean, the medical for
My understanding, you've been paying cash medical, sir, and I think the state just assumed that it was regular Medicaid. Medicaid that was based on economic need, not on Medicaid that was granted to the child based on this child on disability. Your child gets SSI each month, and insurance goes along with that. So there's no charge. We don't order reimbursement through child support on that. But you're still under the obligation to maintain health insurance, sir. You've got it through your work, and of course, looking at ordering you to do that. Now, your order, sir, gives you you do not need the mother's permission to go get a copy of the child's medical records or get anything like that. You have that absolute right under your court order, and you could always show your court order at any doctor or anything like that. Now, the mother is ordered under that court order under certain circumstances to let you know what the medical circumstances of the child are, especially if it's an emergency one. And she's also ordered to give you any and all requests for reimbursement within a certain time. And that's all in your prior court order. So again, sir, I know you're not a lawyer. That prior court order is what, 15, 16 pages long. It's got a lot of legalese in it. And short of it might be a good idea, sir, sometimes when you think you can afford it, to at least go get a consultation and have a lawyer explain to you what all your rights are under that court order. I can't give you legal advice. The state can't give you legal advice, but a consulting attorney can. All right.
Yes, sir.
All right. Next question, Mr. Gwynn.
And the bonuses you had previously mentioned, you've received those for the past 4 to 5 years, correct?
Yeah, probably, yeah. Probably
Okay.
3 to 4, yeah.
And you understand, based on the math, that the child support obligation would become $949 beginning on October 1st, 2024 through March 1st.
I'm sorry, Mr. Gwynn. I thought it was if I ordered him to maintain health insurance, I thought his child support would be $880.
That is correct. That would start on April 1st, however. Am I correct,
Okay.
Judge?
Yeah. Okay. Yeah.
Okay.
Thank you.
And then beginning with, April 1st of 2025, this year would become $880. You understand that, correct?
Well, I understand.
I'm still thinking it's going to be $880, sir, because he's paid the cash medical during that time frame, has he not? I know the new child support amount would start. I'm obligated to start the new child support amount the first day after the service. First day of the month after the service, based on that. But based on that, also same time frame, he was ordered to pay cash medical during that time frame, and so long as he's made his cash medical payments during that time frame, it would not go up to the higher amount without cash medical.
Okay, and I think the concern was that he had not paid the rate based on the current income. With child support being modified, the medical support would likewise, the math on that would likewise be affected.
Okay. All right, then. Go ahead, but I'll rule on that specifically, sir. Thank you.
Okay, thank you, Judge. And I believe, other than asking the court to note that a FINA or financial document was sent, is in the court record.
There were the parties were actually served with a copy of the FINA. Do you have an updated FINA at this time? Or the FINA that was attached to the pleadings? Let me see when it ended. Okay, let's Belinda's bringing it. Thank you. Because the FINA I have ends in as of the technically the 31st day of July of last year. So yeah, just a second. Belinda's bringing the most current. Thank you.
Yeah, this is typical. He's got some obligations, and that's understandable under the circumstances. But this guy is not running from anything. He's paying stuff, and he's just getting treated like a common criminal. Not just in terms of the attitude of everybody involved, and that's what it's like.
Thank you, Judge. Then, other than that, I have no further questions for this particular witness at this time.
All right, then. So, okay. I don't know. I've been doing this for a few years, and I never had anyone request me to make part of the child support payment as a lump sum based on an annual bonus. But you know, that's probably doable one way or the other based on but it would be based on your last on the current amount as of the last bonuser, and that will be it going forward. If I did that, it would be it going forward for the next three up to possibly 3 years. So again, you know, that's kind of problematic. We usually like to spread that out over the entire 12-month time frame. But I don't see a legal reason why I couldn't do that. But again, I've never done it. So I would want to double check to make sure I could do that. I've been a lawyer for years, and we've done lump sum things for all kind of things before, but this is just something a little unusual for the request. Well, your request is something a little bit unusual, and that's not normally done here. So I would want to double check make sure that the court would actually have the authority to do that as a lump sum and not spread it out. But I would probably take that part under advisement. But I'll go ahead at this time, sir, and allow you to ask any other questions or make any and then I'm going to allow the state to come back and ask any questions of either of you at this time. So at this point, sir, anything else you're asking me to do? Any other questions you have, sir?
Sir, are you talking to me?
Yes, sir.
Okay, yeah. No, I mean that's what I'm saying, sir. I mean, I make 42,000. I've sent both check stubs, copies of my checks and all that in. You know, if I can do the 600, which is even a little bit more than the 42, and then do the balance of 3564, I do know I will be held liable for that. That allows me to save throughout the year with my monthly income throughout the year. This is obviously going to be a big. It's going to be hard, you know. So, and that's all I'm asking, sir. So as far as questions, no, sir.
All right, sir. When do you get your bonus each year?
Usually right around Christmas. December 31st.
It's an annual end of the year bonus, correct?
Yes, sir. What's that?
Okay, it's an annual end of the year bonus.
It is. It's not guaranteed, and that's the
I know, sir, but it is. But since you got
yeah.
I can only go with what's happened.
Yes.
If it changes in the future, obviously you have the right to come back in and ask the court to consider what your new income is at that point. So yes, sir.
Yes, and sir, you know, with that being said in there, you know, as a lump sum, I know that I can get on there, and if I get money throughout the year, I will pay towards that lump sum before, and I know. I mean, I have not. The record shows that, you know, I've paid my child support to this point.
All right, sir. Again, technically it's a legal, you know, technically a legal, a legitimate request. That it's just like I said, it just never popped up before. So anyway, I'm gonna take that under advisement. In fact, I'm probably going to send a couple of emails out to my fellow judges to see if everybody else ever does that. We do lump sums for all kind of things, other things, but I've never had it done based on child support and a bonus amount. So again, not a problem, sir, but I will take that part under advisement and get a ruling out on that ASAP. But that's what I'm looking at doing. But I'm getting ready to give Mom the opportunity to tell the court anything else she thinks I need to know. And and again, ma'am, I'm looking at going ahead in order Dad to start the health insurance as part of the court order and get you the necessary, and in the order it gives you all the necessary cards and everything. He has a deadline to get those to you. And of course, again, under the order, if you ask for any type of reimbursement, you have so many days to send him the bill and the request for unreimbursed medical expenses, that sort of thing. So, ma'am, I'm going to start with you. Questions or comments, ma'am? You're muted, ma'am. You're muted. You're muted. You're muted. So.
You want me to take a lump sum child support at the end of the year? I can't lump sum all my bills or anything else throughout the year. And he has a brand new truck, and last year,
Ma'am, that's not it. What's your comment? Okay, go ahead, finish up.
Oh, she is a delicate flower. Too bad Andrew's not here. I know he'd be in love.
comment is I don't want the money at the end of the year because I can't guarantee that he's going to give me whatever his his bonus was. And it hasn't been 4 years. He's been getting them for years. And if we would
Stop. It's a reasonable request. I'm going to take it under advisement, and I get to make the decision here, all right? Because he gets that money once a year, obviously. You're correct. He gets the bonus once a year.
Correct.
Okay, and I can make it's all part of child support, and I don't see a legal reason why I couldn't do it. If there is a legal reason why I couldn't do it, then I'll do it like that. But the bottom line is, ma'am, it's something. It is a reasonable request because he gets the other money all during the year, and you're going to get your percentage of that money that he gets each month. Correct. So it is a reasonable request. But you may continue, ma'am. Thank you.
Had he provided that information when we first set these orders, the child support would have been at probably at this amount right now, because back in 2020 and 21, when the housing boom started, everything was higher. He made more money.
Yes, ma'am.
And he will continue to make more money because Bell County, it continues to grow.
Yes, ma'am. But again, I can only take a snapshot in time. I only could do the math on what the math is right here today, ma'am.
Understand.
All right. Any other questions, ma'am?
No.
All right. All right, Mr. Gwynn, any questions of either party?
Thanks again, Zach, for doing this for me. And it's a great freeze frame. That expression captures her perfectly.
Not of either party at this time. The state would like to note, however, I ran the math, and keeping the medical support from the prior order, that would guideline the obligation starting on 10/1/2024 would become $922, with it converting to $880 with Mr. Krauskopf carrying medical starting on April 1st of 2025.
Chet's enjoying this simping a little too much.
All right, and based on the state's calculations, as far as the math concerned, the bonus the average bonus amount, did you average over the last 3 years, or did you just average the bonus amount for last year? And when you're doing your calculations, what was included? The bonus, did you do a yearly average for a while, or just the average, or just the bonus that was done for 2024?
It was the last 3 years.
Okay, and you know could you tell the court what the average was over the last 3 years for those bonuses, please?
I would need to find that information for you, Judge. Sorry, it's not immediately at my fingertips.
All right, and again, folks, this is, like I said, this is not something we do normally, and sir, there's a good chance that I'm going to say let's go ahead and pay it monthly, okay? Because again, it is technically due then, but again, your request is reasonable, and it's just something I never been requested before, and I'll double check to see one way or the other if I can do it one way or the other. All right, so. And Mr. Gwynn, if you want to go ahead and just give me that information within the next 24 hours, by Monday, I'll appreciate it. Okay, you don't have to do it right now.
Okay, thank you very much, Judge.
All right, folks, I'm gonna go ahead and, like I said, take this under advisement. Again, Mom wants the money all on a monthly basis, sir. You want to do a lump sum? I'll figure out if I can do it one way or the other. But don't be surprised if it's on the monthly basis, because that's the way it's normally done, sir. Okay, so
Thank you.
Because it's complicated and I don't feel like doing math.
all right then. Is there anything else at this time, Mr. Gwynn?
No, Judge, not at this time.
All right, folks, I'm going to go ahead and obviously I'm going to grant the modification. I'm definitely going to go ahead and order the father to maintain the health insurance, sir. You'll have, I'm not sure what Mr. Gwynn, how what's the deadline on I usually make it, it has to be done within the next 30 days. That's the way I normally do it when I when I render on the record. Is that the norm on your order?
I'm sorry, Judge. I'm not sure I understood the question.
Okay, then I'm gonna go ahead and make it part of the order that the dad has from 30 days from the court signing the order to get the health insurance set up through his employer. Okay.
Okay.
All right. Once I sign the final order, I'll go ahead and then he has 5 business days to get the mom the necessary cards and information so she can use it. All right.
Yes, sir.
Okay. All right then, and I'm gonna go ahead and ask you to get me that data on by that's this coming Monday, and I will go ahead and once I get the data, I'll go ahead and confirm whether or not I'm going to do this on a monthly or a lump sum amount. Again, it's just like I said, it's a reasonable request, but it may not be something I can do one way or the other. The math may not work out. So anyway, I'll double check and I'll make that ruling as by Monday evening. Thank you.
Thank you.
Thank you.
All right, so again, new child support amounts of $880 a month starts the first day of April. Again, sir, mom was entitled to a finding of what the child support should have been starting after the first day after service. So the court will be granting child support of $921 for the month of you said starting on the 1st of September to the 1st of October, Mr. Gwynn.
Starting on October.
Okay, so 921 the 1st of October. So that's October, November, December, January, February, March, and March. So for that's 6 months of time frame. And the court will go ahead and make a ruling as far as the tell you what, I'm sorry, the 880. I'm sorry, I knew I was messing up somewhere. The 880, the court will confirm whether or not that will be the new child support amount starting April 1st by this Monday at 5 p.m. or whether or not I'm going to do the difference and give Dad the lump sum that he's requesting. All right.
And then I believe you said 921, Judge. The number that the state had come up with is 922.
Oh, sorry. All right. Yes, I missed it. All right, 922. Got it. Okay, thank you.
Sir, do you mind if I ask a question?
Yes, sir. What's your question?
That would be 922 starting in September, but that would what I've currently been paying in child support will be deducted from that amount, correct?
Yes, sir. You'll get credit for what you've paid during that time frame, sir. The difference, the only thing is that you would owe, sir. Yes, sir.
Okay.
All right. All right. Anything else, sir?
Yeah.
All right. Anything else, ma'am? All right. Anything else, Mr. Gwynn?
There's not, Judge.
All right. Thank you all very much. And Mr. Gwynn, like I said, you get that to Belinda by Monday, and I'll get that right back to you. Okay.
And I'm sorry, the arrears confirmed as of 09/30/2024 with repayment. Do you have a ruling on that?
I'm not going to order repayment on those small amounts, sir. Again, it sounds clerical. Just I'll tell you what, go ahead and order repayment at $5 each on both of them, okay? Because again, the math's going to change over the time frame. And again, it's such a small amount that yeah, I don't usually even order repayment judgments on anything that low, sir. So, but go ahead.
Understood, Judge.
Go ahead and order repayment at $5, and we'll see how it comes out.
I'll pay it. I'll pay it in the lumps. I mean, I'll pay that. There ain't no.
Okay, again, sir, that was.
I had no idea it was even out there. So,
well, yeah. That was as of that date, but again, it may be different today. So, but you can go ahead and pay that lump sum if you want to, sir. No matter what, it'll put you at least they'll link you even or ahead. All right.
Yeah, I got you.
All right.
One other question, just real quick. I'm sorry. As far as the visitation deal, I'll file that with the district attorney's office. Is that correct?
No, sir. I can't give you legal advice. This is a civil matter.
Oh, okay.
The district attorney, you would need to go talk to your own legal counsel or figure out how you want to do anything. But obviously, anything dealing with this case can be updated or modified until the child turns 18. And if the child's going to need special needs care after the age of 18.
Already planned it.
Okay, so yeah, you need to start getting something done about that 15th, 16th birthday. That way there's a smooth transition, okay?
Gotcha.
All right. Thank you, ma'am.
Thank you so much.
All right. Thank you very much, and we're off the record.
Can he hear me?
Yeah, everyone can hear you, ma'am.
What visitation are you concerned about, Joe?
Oh, ma'am, y'all need to do this. Everybody in the world can technically hear you right now because this has been broadcast on YouTube. You might want to go ahead and talk to each other privately, okay? So sorry. Under the law, I've got to broadcast this on YouTube, so you might not want everybody to know your business. So
Don't worry, Karen Mary. Nobody saw.
This is in the District Court of Butler County, Kansas, case entitled, in the matter of the estate of Robert J. Kerner. It's case number 2023 PR 123. Beginning with the lawyer for the co-executors, would counsel announce all appearances for the record, please?
Yes, Your Honor. Lisa Machakow and Jenica Nelson appearing for Kyle Corner and Christy Garens, who are the court-appointed co-executors using the last will and testament of the decedent.
Yes, Your Honor. Austin Parker for one of the beneficiaries under the will, Whitney Corner, as well as claim for under the petition for family allowance and spousal allowance, Miss Helen Corner. Thank you, Your Honor.
So Helen participates with audio only, Whitney with both audio and video. This matter comes before the court at this time for hearing on a petition for final settlement and approval of a valid settlement agreement. Ms. Machakow, I presume that
we got us a probate Donnybrook here.
You're just asking for approval today, correct? And I'll expand on that here in just a little bit. But Mr. Parker, from you and your client's perspective, is there any objection to this court granting the petition for final settlement as submitted to the court?
Yes, Your Honor. Not the actual settlement agreement. I have signatures held in escrow for from both Helen and Whitney concerning the actual final valid settlement agreement that discussed the appropriation of what was agreed to in terms of value to Helen. Okay, for the allowances, the homestead allowance, and then the spousal family allowance. Both of those figures have been agreed to. The real question is, there was a, and I was optimistic originally about this, Your Honor, but there was a attempt to go on ahead and try to come up with even the need for this hearing to do the final accounting for the.
Oh, sorry, Austin. It's just a cheap shot for no reason, but it did amuse us.
Estate. That's really where the questions come in. So the signature are held in escrow out of an abundance of caution, because there was some language that, hey, we're not disputing any of the. I didn't think it went this far, but there was a question from my clients about are we able to ask some questions during the final accounting, because we don't understand where some of the things, particularly with how many hours were worked by the co-executors of the estate. There's not really a description of what they did, just some time for it, and we're not exactly sure how all that adds up. So that was one of the questions, and then also exactly on the final accounting where some of the assets that were sold over and above the mobile home park. Those were the two main questions that were on it. But by signing the final settlement agreement, they didn't want to remove their ability to ask those questions at the final accounting. So the signature held, the settlement agreement. My clients are in agreement with those allocations for, again, for what Helen is to receive. It's really the questions are relative to the final accounting, if that makes sense, Your Honor.
Well, I think it does. Is there an itemized listing of the time spent, what it was spent doing?
Your Honor, I don't want to speak on behalf of opposing counsel, but if you look here, they've provided some printout lists of time work. I would be happy if I could share my screen, Your Honor.
You may do so.
Thank you, Your Honor. I'll just use an example here. This is some of the hours that were worked by Krista Gearens. Okay, so, and this is these are recorded hours. So they record what the hours were, and then they bill at a $50 per hour rate. 7.68 hours here, 1.02 hours, 0.48. This was produced to us here in the last, I would say 60 days. Okay, so this is for that month of April. So in the month of April, there were two people. This is for April 2024. There were two people, and this is Kyle also as well. 41.88 hours from him at $50 an hour. This is just an example of what the breakdown looked. And this was generated October 6, 2024, from what I can see here. So you have that, 41.88 hours. And then if you go up here, 33.68 hours. So this is better than 75 hours managing a 20 lot mobile home park where they hired someone else at $10 an hour to do the mowing. So what I'm trying to, and that's at least my understanding, what I'm trying to figure out is,
Your Honor, I'm going to
would
have
they
to
spend
object at this
75
point.
hours doing
That's just not truthful. It's not even what's been presented in the final settlement petition. If it's clearly stated, it's $35 an hour.
Okay, well,
I ran this mobile home park for a year and a half. It wasn't cash flowing when
I don't know. I'm with him on the skepticism. At least prove it to me.
it was the decedent's business. It cash flowed significantly now.
Yeah,
But
Mr. Parker, I
that's
think
all been
just a
previously
moment, counsel. Just a moment. Mr. Parker, yeah, the petition for final settlement seeks a reimbursement rate of $35 an hour, and so they're bound by that.
Yes, Your Honor, I have no objection with the hourly rate at 35. Quite frankly, even if they were at 50, although I would question that, I'm more interested in what did they do for 75 hours in the month of April to manage a 20 lot mobile home park. And in here, the hours, they say 1.6, 7.68, 2.3. There's like, if I build like this, they don't have any code for what they did. They just said, I did 7.68 hours of work, and I don't know what that is. And I don't expect them to be able to go back at this late date and say, this is what I did on this date in April. I'm just saying logistically, I'm not trying to get into their business. I'm just saying, I don't know how you spend 75 hours collecting rent from 20 people in a mobile home park. I don't understand that. And that's really where my clients are coming from. They don't understand how could you spend 41 hours a month running a mobile home park?
Well,
Is there a response?
Absolutely, Your Honor. So back in the middle of early February, an itemized task list.
I'm torn here. Like, I think it's a fair question to ask that the attorney's asking, but I'm thinking, just as he said it, like, I don't know how it would take that long to collect money from 20 people at a mobile home park. And I'm thinking, I could imagine it. I can imagine that's an ugly task, honestly.
Was provided to counsel, Mr. Parker. And this is an operation that went on for a year and a half before they were able to effectively sell the mobile home and the business of operating it. There are 20 manufactured homes that sit on the site, with about 3 of them being tenant owned. The rest are owned by the mobile home park. There's common grounds. There's a lot of repairs and maintenance. One trailer
There's all the deliveries for the meth labs. There's a lot going on.
Had a hole in the floor where a family of raccoons was coming through, and to coordinate all of that work, not to mention they only had a property manager for the month of August. The rest of the time, it's been Christy and Kyle actively managing this property so that they could collect back rent owed, that they could actually get rent paid in a timely fashion. And then they've been able to make this business cash flow to the tune of about over $100,000 over the year and a half that they've been operating it. Where if you review the tax returns, which were also provided, and this background information was also provided to Mr. Parker, that it was running at a deficit.
Okay, I'm with Zach. I can't believe they're dicking around over these low amounts of money, but I'll be damned. I think they both made good arguments. He's like, I just want some justification of this. She comes back with nothing specific, except one damn good argument, which is they took it from nothing to cash flowing. That has value. Presumably that benefits the estate. And that is verifiable.
And not cash flowing year over year. At least I think we provided 5 years of the 3 years of the tax returns before decedent passed. So this was not just a rent collection where you send timely rent payments in the mail. This was a hands-on,
Of course, the fact that it was showing a loss on his tax returns doesn't impress me much. That could easily be he's taking cash under the table and cooking his books. I mean, I don't know this guy. I'm just saying. A
lot of repairs and maintenance had to be done even on the common ground, where Kyle Corner actually fell and broke his leg doing some of this work to try and make this business cash flow again and to correctly position it to where they could get $500,000 in the mobile home park sale. So and with multiple sales of
broke his leg. I didn't even battle him at the Republic for this one.
This mobile home park actually fell through. So not only did they have the business operating and managing the day-to-day activities of that, they were also trying to get buyers to list this, to be interested in it, and to actually do the showings of that mobile home park. So it was not just a small endeavor for them.
Your Honor, I try to be intuitive about these things. I'm not trying to pick on the co-executors of the estate. I'm simply question, and I think that's where my clients came from, is they question.
Your Honor, I didn't get this turtleneck by not doing my job correctly.
How you'd spend, or why you would spend 75 hours a month, 60 to 75 hours a month on average with 2 separate people working to collect rent checks. I mean, again, they're the executors of an estate. I'm not trying to put words in their mouth. I understand that they chose to run it the way they chose to operate it as the co-executors of the estate. All I'm saying is that they knew full well that the court was going to look at this from a final accounting perspective. They came up with a list of tasks. I'm not even challenging that the list of tasks were performed. I'm simply asking, they chose for whatever reason to spend 70 hours, 60 to 70 hours on average. And I just showed you 3 months of average time put together. I don't know why, but I'm not sure that they should have more than just and I think that's what my clients were going to say. Why, particularly all the money that they get separated here from the estate, it's just dissipating the benefit to the other beneficiaries. Why can't they just have $500 each per month with a set number of average hours, since we're not going to be able to go back and allocate what they spent all of their time doing, just the list of tasks? We won't know what they did 7.68 hours of work because they didn't write it down next to it to quantify it during that day. So would it be maybe more reasonable to say, here's $500 per month for each of these people that were working as the trustee beneficiaries? And oh, by the way, you're not really losing much because you're just increasing your 1/4 beneficiary share that you're going to get anyway. It's actually probably a tax advantage for them because they're going to have to count this as ordinary income, where the other one, they don't have any tax on it. So it's probably almost a wash. It just seems like instead of my client signing off on 30 hours or 40 hours from a non-contested standpoint, at least they didn't feel comfortable signing off that they weren't going to ask the court to at least look at what justification.
And Your Honor, I'm going to object again, because that absolutely misrepresents the information that's been provided to Mr. Parker. We specifically showed that it's 15 hours per work week is the estimated time that these co-executors were working in the business. It's not the abnormal time of when they first had to operate it, when they were first taking it over and isolating it in 1 month. But if you
Any objection? All objections.
you look at the 1.5 years that they were operating, it comes up to roughly 15 hours a week. Or
530 days.
yeah, and it's 530 days they operated this business.
Oh, I leave it to the court's discretion. I showed you 3 months, Your Honor, of every month looked at about the same. I could pull up other months where you would see that the fluctuation is. And Lisa, please, counsel, if you have other months that you want to share or something to controvert, I'm just going off of your exhibits. I'm just saying I don't understand. Those were hours that they provided me. I just pulled up one of the hourly lists. There's no quantification of what they did during each of those hour time. There's just a bulk summary task list. That's not
Yeah.
how we bill, at least as
And Your
lawyers.
Honor, if you need, I'm sorry,
You're
if
right
you
about that,
need
Mr. Parker.
a
You're right
trial
about that.
to, if you need a trial to understand exactly the work and exactly the averages and the amount of hours worked and what tasks were accomplished, we would be happy to set it for trial so that you could hear proper testimony and actually have proper evidence in front of you to look at the 1.5 years of worth of work of these administrators. So we'd be
You'll never believe this, but I'm really not a turtleneck kind of guy.
happy to do that. However, just in preparing from the time when we had a valid settlement agreement without getting execution pages as the agreement, which Helen and Whitney waited until a best and final offer was expired to go ahead and accept it when we were 2 days before a mediation date, where we'd already worked up to go to mediation with a mediation statement, with preparing our trial exhibits because our trial was set so soon that we had an absolute agreement in the valid settlement agreement of a set date for closing this estate. That wasn't our offer of settlement. I had to go back to my clients to see if they would honor their best and final because it was actually an expired offer, which my clients agreed to. So it was their settlement offer that ended up being accepted in the valid settlement agreement. And part of that requirements that their clients wanted to have was that this estate would be closing on February 17th, as represented in the valid settlement agreement. And we could not do that unless there were the consents to doing the final accounting because of the significance of all of the work that's transpired and how long this estate has been opened up. But they didn't perform on that. They didn't provide their signed pages for us to actually be able to file the petition and with the fully executed settlement agreement like we would have expected to do. So they're causing a lot of additional work and expense to this estate to the tune of now we have an additional $2,000 by Jenica and me to keep litigating about things that should have been settled and agreed to in the final settlement.
Your Honor, I'm just working off of what counsel provided me. I'm not trying to challenge. Counsel provided me a statement that was prepared. The list here in 2025, this is what they told me at the bottom of their third page. Being asked to write down all activities performed as executor now because Austin, Helen, Whitney do not believe the amount of work it takes to manage the estate of Robert J. Corner. That leads me to believe that they tracked hours. They didn't create this list until after the fact. They created a list of items that were performed. I'm not trying to get into the metadata of when they created what they did in 2024 or 2023. I'm not trying to turn this into a matter of extreme
Ooh, let's get into the metadata.
litigation. I'm just trying to say, look, I'm just going off what they provided. I fully assumed that before they provided these documents, they provided me these documents in an email on the documents justifying the hours worked, okay, on February 7th, 2025.
Yep.
These documents were looked at and reviewed. I forwarded them to my client on February 11th. The scope and nature of our settlement discussions were not relative to the final accounting. They were relative simply to the final settlement that we agreed to was not the final accounting. That was to go to the judge. The final settlement was only supposed to be for what the spousal allowance and what the homestead allowance was for Helen. And so now we're talking about issues relative to final accounting. I'm not even saying we need a trial. I'm just saying, look at their exhibits. Their exhibit that they provided, the primary one that I'm most focused on here today were the hours calculations. This right here, which is what Kyle said apparently at the bottom that he prepared now. I'm not trying to challenge that. He just said he prepared that. And then here is a summary of the hours that Kyle said he worked and his expenses. This is the best I have. I have hours worked in August, and they range from 23 hours up to 63 hours, but that was an outlier in the middle of it in 24. But it seems like it was about 30 to 35 hours a month. And I'm simply questioning, why did we work 35 hours to manage a 20 unit mobile home park that was being positioned for sale? And if there were going to be that much management, why didn't just one person do it instead of two people doing 20 to 30 hours each? And I'm not saying that I understand the operations of a mobile home park, but it would have been a lot easier for me to justify to my clients if they would have put down, this is what I did this day. You know, these aren't my questions so much, Your Honor, as they are my clients saying, what did they do? I don't understand. They don't even live in El Dorado, Kansas. How did they spend 30 hours a month doing this?
So I'd like to have you take judicial notice of what was filed before this court on February 26th, 2025. And specifically the Exhibit B that shows the valid settlement agreement, and also the emails showing that we had offer and acceptance of the valid settlement agreement.
Your Honor,
Parker,
if
you claim that the settlement agreement doesn't cover the issue which is currently before the court?
yes, Your
It
Honor.
actually,
Okay,
It-
Mr. Parker, I'm addressing Mr. Parker.
Yes, Your Honor. My clients agreed to a settlement agreement. They opposing counsel prepared it. I looked at the form. I sent it to my clients. They looked at it. They said, wait a minute here. This is above and beyond the settlement agreement that we agreed to, which is we don't want to agree to not contest the final accounting before the court. We agreed to the settlement of the spousal allowance and the homestead allowance, because that's the only matter that my clients had a petition before this court. They didn't even have the ability to agree to a final accounting before the court because they didn't have standing to do that. They only had standing, particularly Helen, to agree to her spousal allowance and her homestead allowance. It's up to the court to determine what the final settlement is. So they agree to the spousal allowance and the homestead allowance, but they don't have the ability to negate the court's determination on a final accounting.
All right. I'm asking, is there a provision that was confirmed by both parties that would address the issue that's currently before the court or not? Was this left open
Has anyone brought up jurisdiction?
for determination by the court at final settlement?
So there is an agreement in the valid final settlement. It's a subsection G. It's the full estate distribution. The estate residue distributions will be made to the will beneficiaries and children of Robert J. Corner no later than April 1st, 2025, as long as the court orders approving the final settlement is received with the schedule of distribution. The co-executors agreed to complete the formal final accounting of the estate to be filed with the court on March 14th, 2025. So they did preserve their rights to review the final settlement. We will not be able to close, but we can do a trial so that the proper evidence and testimony can be heard on the amount of hours and work, and then the court can make its determination.
Which adds to the legal fees, which will be owed by the estate in this case.
Yes,
You
Your
are
Honor.
correct.
That's all we're doing is saying we just wanted the court to look. And quite frankly, Your Honor, again, I'm not trying to extend this. I'm trying to do the opposite. My clients don't, without presuming what evidence will be heard at trial, all they wanted to do was get to the final accounting with the court, and then the court to make a determination: are we going to pay these hours without linkage to what tasks were performed, or are we just going to come up with a blanket? Okay, if you say it's 15 hours a month at $35 at 35, if that's what the average should be, right? $15 or 15 hours a month times 35, that's $525 a month. Can we agree to a set fee for the administration since they didn't account for what they actually spent the hours doing in real time? Or do we have to go off of what they said? This is 31 hours this month, 64 hours this month. That's all I think that's all my clients are getting to in the final account.
Mr. Parker, this is not a new situation. The people that are making this claim for reimbursement have been managing this mobile home park for many, many months. And this was not suggested earlier that they be put on some sort of monthly salary for performing these services. I think they proceeded in good faith and conducted the business that the mobile home park needed. And I understand that there is a legitimate concern anytime that they do not itemize each and every time they intend to bill. Quite frankly, that's what I would expect from a lawyer,
right,
to justify their bill in a case.
Okay, that'd be a no.
However, overall, what the court needs to determine is, are the fees that are being charged in this case reasonable given the scope of the work that they were asked to perform as fiduciaries in this case to manage this park? And the court will make a determination at this time that it does not have enough information before it to make that determination on a disputed issue. I don't think that these itemized statements, to the extent they exist and that you screen shared, were filed in the case, nor would I expect that they would be. But they are available and the court is going to need to review them. So the question is, who's going to provide those to me?
Your Honor, counsel, Lisa, would you prefer to do that? They're your exhibits. I don't want to presume to provide your items.
We would be happy to provide that with also the analysis that of the total hours using the time clock application that they use to track their actual hours performing work tasks for this business. We would be happy to provide all of the information that we provided earlier to Mr. Parker.
Okay, and that's really what I'm wanting. I want what he received from you.
Thank you, Your Honor. And we defer to whatever the court's decision is on what this is really, my clients just wanted the court to determine what they should or shouldn't be paid prior to the final settlement being approved. That's it, Your Honor.
We need this estate settled in a final fashion as soon as possible.
Yes, Your Honor. I don't think we need any.
Yes, and typically at this point, we would also be showing our added attorney fees and legal expenses for preparing for the hearing today when we thought some of this was being handled with the valid settlement agreement and not getting those signed pages to actually properly demonstrate to the court we had a deal on resolving all of these spousal allowances. To review that matter, as we'll have, again, other legal fees and preparing the documentation to submit to the court.
Ooh, she's feeling her oats now. Lisa's on fire.
For your review and perhaps even an additional hearing on it.
Well, email me your additional bill. Counsel, you will be obviously having to draft ultimately a journal entry of final settlement in this case. I know this may have already been roughed out and be ready for just to be adapted based on the court's eventual ruling on the fee issue, which is currently before the court. But send that to me and then copy in Mr. Parker. Just send that to me by email.
Thank you, Your Honor. I sincerely doubt that we'll need a hearing. Whatever the court's decision is off of the documents, I'm not trying to, I want this, just as the court said, this should be wrapped up as soon as possible.
Well, what is the hourly rate that I'm going to see on this additional billing?
So we're billing at $325 an hour with our paralegals at $100 an hour. I believe that's correct.
All right. Thank you for that information. I look forward to receiving it.
Thank you. And we'll make sure to do that with your assistant, Mandy. We'll email everything to her directly, or is there a different email address that you would like to send to?
Send it to Mandy. Mandy will get it to me.
Thank you, Your Honor.
Thank you,
All
Your
right.
Honor.
Is there anything else that we need to address as part of this hearing?
No, Your Honor, I will circulate the signature pages since now really the final accounting issues that the court's looking at to all my clients. I'll get fresh signature pages over to opposing counsel here by close of business Monday. Thank you, Your Honor.
Very well. All right. Well, I'll look forward to receiving these emailed materials, and the court will try to make a prompt decision in this matter so that we can reach eventual final closure of this estate in the very near future.
Thank you, Your Honor.
All right.
Thank you, Your Honor.
Then if there's nothing further at this time, Kerner estate matter will be in recess. This meeting may be ended for all at this time.
Why are you unnecessarily wasting the judicial time of this court?
Okay. I don't know. I don't know if we want to take this on here. I can do it. All right. So I did. I can't think of this guy's name. Zach, where are you? This guy, I did a case. I did a prior video on, and he's a stalker, allegedly. But from what I'm seeing here, he really looks stalkery. So we have an updated court appearance, and it's long, and I don't know if it's good because I haven't seen it. But Zach goes and actually does a little digging and finds this, which is surveillance video of this guy stalking his butt off. It's pretty good. All right, let's give it a look. Let's see how far we get. I don't know where he got this, but it looks like the guy that was in court. And it looks like activity that could be described as stalking to me.
Okay, good afternoon, everyone. Do we have
All
everybody
right.
with us?
Well, I can't remember how it ended last time, but he was really not convincing it whatsoever and kind of out there. Rutvik, there we go. Thank you, Zach. This guy's name is Rutvik. I'll hunt down the prior video and put a link in the description when I get a chance. But here's the next appearance. Let's see if anything happens.
Yes, Your Honor.
All right, thank you. Mr. Rudvik, good afternoon, good morning still. All right, looks like we are on the record here. So let me call the cases, and then I'll kind of put the issues and what we're here for out in front of us. And this being preliminary, yeah, if there's anything preliminary, Mr. Rudvik, I'll certainly turn to you first. I did get your GR 33 request. I'm ready to address that, but let's put all the cases on the record first. So this is City of Bothell versus Eric George Rutvig. This is 4A012-1127, 4A016-3547, 4A033-8194, 4A034-6618, 4A034-7768, 4A038-9925, 4A080-02850, 4A092-1007, 5A0082276, 5A016-5251, 5A016-5252, and 5A016-5253. Last few are on for arraignment. The others are on for pretrial. We are here from the continuance from 2 weeks ago at Mr. Rudvik's request to prepare and receive at least the probable cause statements for the purposes of the arraignments and the discovery for purposes of the tracking pre-trials at this time. Mr. Rudvik, I did, as I indicated, I received your GR 33 request for accommodations. I appreciate that. That was, you included some documents, you're requesting all of that under seal. I'm going to grant that. All of this is under seal at this time. It is not open for any kind of public records request or anything. Just to be aware, Mr. Rudvik, anything filed in the future regarding this, if you want to either supplement that or anything, would have to be filed under another request to seal. right? Just so you're aware. So, okay, so you just can't assume anything that's related to this is automatically under this seal. It's got to be specific request every time, okay? If it's related and applicable, absolutely. I have no problem sealing these. I just want you to be aware, like sometimes I get, somebody will attach it to as a plea, to a pleading or something like that. That's not the case. Without a request to seal, automatically goes into public record, automatically subject to freedom of information requests. Okay, just so you are.
That's why I asked for some way to seal it.
Yep, and I know the City of Bothell staff definitely sent you the sealing. I have had a chance to look at the request for accommodation, and it looks to be based on at least one diagnosis and the request is at this time a reasonable request. Specifically, you're requesting a little extra time to get things done, slow down a little bit, and then breaks to allow you to catch up. I think that is very reasonable considering what you have provided me. Again, the caveat is within reason, but I myself want you to know that I'll be dedicated to taking it a little slower, both in my speech and my pace. And I will work to check in with you to see if you need any breaks. Obviously, as this moves along, depending on what we're doing, preliminary hearing, evidentiary hearing, or a trial, the reasonableness does shift a little bit, okay? Because I have to take a lot of stuff into account, but I'll do everything that I can to address this request as I have just granted it. Okay?
I'll tell you one thing in terms of asking about catch up. I may not figure it out till later.
Understood.
So
understood. The nice thing about, and that too is, a motion to a court, if done properly and within reason, is always just that. You're just asking for something. So if something clicks later on or you catch up later on and you said, Judge, I wanted to make a motion before, if I'd have kind of caught up with that. Most of the time, Mr. Rubik, I allow anybody to do that. Again, there are some things that maybe if you don't call it in time, it's kind of waived or we're past that. Just kind of be aware of that. But most of the time, any motions usually can be brought up, even if the issue was dealt with maybe a day or two earlier, but then something clicks or some new information comes to light. Okay.
Thank you.
All right. So with that in mind, my intention is to proceed to the arraignments at this time.
Can I ask you a question first?
Sure, go ahead.
I have a witness that I read your bail rules and connection to the community. Somebody willing to stand up for you? Apparently, it carries some weight. Norgan A would like to speak, but she's only available till noon.
Okay.
So, and it's probably like a 5-minute deal, and I can ask her to zoom in whenever you want.
Yeah, that's your right, Mr. Rufik. Can you have her zoom in now?
I'll have to do it.
Yeah, please do. The arraignments themselves won't take too long, but regarding the bail hearing, I'll give you a chance to position yourself as well as call any witnesses you might want to call. Let me ask the city, Mr. Johnson, is the city prepared to proceed to arraignment at this time?
Yes, Your Honor. For the record, I'm standing in for Mr. Laurie. He's not available today, but I have his notes, so I'll rely upon those. But yes, Your Honor.
I understand, Mr. Johnson. Thank you. Thank you for being here. And Mr. Rudvik, whenever you're ready.
I've texted her to zoom in, and presumably she's doing that.
Okay. All right. Well, while we're waiting for that, we can proceed to the actual arraignment. I know, Mr. Rudvik, you've been through this a number of times before, but I'm going to do it just as we're expecting to do it at any case at any time. So really what we have here is we have several cases, and there's a couple counts under one of the cases. So regarding case 4A0921007, you've been charged with 4 counts, separate counts of violation of an anti-harassment / protection order. Again, all of these are non-domestic violence. So Mr. Rudvik, is your true and correct name Eric George Rudvik?
It is.
And date of birth is May 1st, 1959?
Yes, it is.
Okay. So now, regarding the protection order violations, allegations under 007, all of those are gross misdemeanors, which means they're all punishable by up to 364 days in jail and a $1,000 fine, sorry, a $5,000 fine each. Okay, gross misdemeanor. These are on or about the alleged
All right, I'll fix
days of December 23rd,
Thank
December 22nd, and December 24th, on or about that kind of time frame. I have had the opportunity to review the officer's sworn statement. In this case, I do make a finding at least the level of probable cause has been established to move forward with something like this at this time.
I want to object to probable cause on this.
Okay, your objection will be noted. Defendant is objecting to the court finding probable cause at this time. Okay, that's on the record for you.
Do I get to argue any points, or?
Sure, you can argue that. You can argue points. Go ahead. I'll give you, you know, a little bit of time.
I believe this involves me allegedly flipping off his camera. Well, that's a protected First Amendment issue. Let's see.
Yeah, I'm only interrupt. I normally wouldn't do this, but I'd only interrupt that. I would just note for the record that Mr. Ruvig's statements, although he's pro se, they can be used against him. I want to make sure that he's advised of that.
Okay, thank you, Ms. Johnson. I agree with that. Well, Mr. Ruvig, you're representing yourself. You can say anything you want, but again, anything.
I understand.
Let me do it again. Again, this is my job. Anything you say can be used against you, okay, at your trial or subsequent hearings, just so you are aware, okay? With that in mind, go ahead. What do you want me to know?
I guess the first thing I want to say is that these are retaliatory charges that I believe Sothallor dismissed, and because I called him out for lying in court on October 8th, that's how these came about. But the particular charges, you know, it looks like on 1222, I assume I'm correct, is that allegedly I'm flipping off a camera. Well, okay, well, so what? That's a protected First Amendment speech. So where's the probable cause? Where is that a anti-harassment protection? You know, and then the second, third, and fourth involve some cardboard in the common area, which is not under Pedro Rios's control or authority. That is there for the use of all people on the property. And in particular, I thought it was funny that one of the videos showed cardboard being kicked down the stairway. Well, what do you think that, you know, I threw it up there and then just to kick it back down? That's evidence that Pedro was harassing me. So I don't think there's anything there that rises to a violation of a protection order. And again, this is retaliatory because of my having called out Sothallor for lying to the court. And the police reports are full of hyperbolic statements that are irrelevant. And one second.
Okay.
I'm trying to find, I highlighted some things.
So, Mr. Ruvig, just so you're aware, what we're doing is having a, you know, you're arguing against me finding that there was probable cause to at least proceed on the charge at this time. Just so you were aware, cause is me finding that based on the facts that were provided to me in the officer's sworn statement, that there's a mere scintilla of evidence that a crime was committed. I am not making any finding whatsoever that absolutely beyond a reasonable doubt that the crime was committed. That's for you to argue against.
Well,
me at an 8.3 hearing, which I know you want, an 8.3 motion, and or
oh, we got a scintilla, no problem. I don't know if we have a conviction, but we got a scintilla. Not even trying.
To a jury at a jury trial. So you're bringing up very good points. You are, right? Your First Amendment rights, or whether your acts even constituted a violation beyond a reasonable doubt to the order in question. That's for a fact finder, whether it be me at an 8.3 or a jury at a jury trial. I just want to let you know the level of proof that needs to be provided to a court for a probable cause finding is a lot lower. Okay. So in case there's an appeal later on, you can refer back to your objections because they would be timely. That's what we're doing for you. But I will tell you, I've read the PC statements. I understand, and you've made similar kind of arguments before, so I'm aware of all that. I still make a finding of probable cause on that. Okay. So let me ask you this: Do you understand the 4 charges in this case against you?
Yes, but I would say what I've read about probable cause is that it's a standard where a reasonably prudent person would have reason to believe a crime has been committed. And I just don't see that anywhere in here.
Okay. Okay. Hey, I get it. I'm not asking you to agree with me. Okay. This was my ruling. You've made your objection, and you certainly can appeal that at a later time. Okay. So what I'm going to do, Mr. Rutvik, is I'm going to go
One
ahead.
other point is that it's also based on a court order that court had no authority, no jurisdiction to issue the order that it did for that area.
Yeah, and again, I understand that that's part of your motions as well. In regarding the probable cause, it was relayed to me that the order was signed by a judge. If you challenge that later on and a higher court agrees with that, obviously that puts this whole thing in a different light. But for right now, again,
What I don't want to end up is in jail over this.
I understand. But again, that's why we're going through this very slowly, procedurally. Okay. So I found probable cause for these 4 counts, accusations, at the end of December. I'm going to enter pleas of not guilty on your behalf at this time, counts 1 through 4 under case 007. Regarding case 5A00822276, this is a charge of placing a person in fear or with threats, alleged to have occurred on or about January 29th, 2025. Found probable cause there as well. Again, the low level of amount of evidence, but I found it there. Your objection will be lodged. You're objecting to the court finding probable cause there. I'll let you talk in just a minute, but that is a simple misdemeanor, meaning that this one is punishable by only up to 90 days in jail and a $1,000 fine.
There's actually no jail time associated with this.
It's a simple misdemeanor under the Bothell Municipal Code. So
that's fine only. In fact, it says that in the charging document.
Mr. Prosecutor, do you see anything else other than I see?
I'm sorry, which case was this? There's so many of them. I apologize.
This is 2276.
Okay, let me look.
It says maximum penalty up to $1,000 fine pursuant to BMC 9.05.040D plus restitution assessments and/or costs.
This is in a charging. This is something you got from that the city produced. I'm going off of the Bothell Municipal Code and the RCWs regarding the definition of a simple misdemeanor.
Well,
it says something different.
The municipal code has no jail time.
Oh.
This is all interesting, but not really applicable. I'm going to look it up.
It's relevant to any bail question.
We'll go back to that one, Mr. Rutvik. You posed the question. It's up to the prosecutor to come forward with what they're charging you with. I just want to verify that. All right.
And he also is requesting obscene bail on it.
And we'll get to that.
Yeah.
So next case is 5. We're gonna.
If I might identify some things first.
No, I'm gonna move ahead to 5A0165251. Okay. So in that case, you're being charged again for another anti-harassment or protection or violation, non-domestic violence, alleged to have occurred on or about 12/11/2024. I was able to find probable cause there as well. Again, gross misdemeanor, up to 364 days in jail and a $5,000 fine. Do you understand the nature of that charge against you?
1 second.
Sure. And is it Miss Ganetti? Can you hear me okay, Miss Ganetti? I think she's frozen right now. No, she's there. Miss Ganetti, can you hear me? I don't think she can hear me, Mr. Ruvik. You want to send her a text, let her know that I'm trying to address her. Maybe she doesn't have her speakers on. Okay. Thank you for doing that. Again, we'll address her at the bail hearing coming up. All right. So, Mr. Rubik, you understand the nature of the anti-harassment protection order from 12/11/2024. You understand what you're being accused of?
No, I don't.
Okay, that is like all the others. So you do understand because you've
Well,
already
the particular issue.
Well, you've got the probable cause statement. Okay.
Well,
The government is alleging that whatever you did on that day was in violation of the protection order that was signed by the other court.
Well,
So
it doesn't say anywhere.
I'm going to enter a plea of not guilty on your behalf. Okay, and you'll be able to
Slow down, please. I want to catch up to what we're talking about here.
Okay.
This alleges that I pushed his chair aside, and that was a violation of an anti-harassment order. I don't know how that could be.
Again, something you'll be able to argue to the jury.
Well, the thing is that it doesn't rise. There's no element of a crime here. How is that a violation of an order? There's, that's a walkway there, and people walk by it and Rios leaves stuff out in the middle of the walkway.
Understood.
And the condominium rules don't allow that. So I'm just trying to figure out how does a reasonably prudent person determine that a crime's been committed, possibly, and even at a scintilla level, it doesn't add up for me.
All right. Well, your objection is noted. I still make a finding there is probable cause from
even at a scintilla level. My night's made.
What I've read and been provided. So I'm in our plea of not guilty on your behalf on that. We're going to go
Nora's
back.
trying to talk.
I'm sorry?
I think Nora's trying
Okay.
to speak.
Miss, is it Gennady? Is that how you pronounce it?
Gennady.
Gennady. Miss Gennady, if you're talking to the court, I can't hear you. Is she talking to us?
She's talking to somebody.
That's right. Yeah, I can't hear if she's talking to us.
If you don't mind my calling her.
Okay, that's fine. Mr. Johnson, you ready to go back on the 2276 when Mr. Rudvik's ready?
Yes, whenever the court's ready.
All right, thank you.
Well, they want her to go to a breakout room or something.
Madam Clerk, she can, unless there's an issue, she can stay here. That's fine. Rather than try to get her in and out of breakout room. Okay. So, Mr. Rudvik, she's working with the clerks on that. We're going to go back to 2276. Mr. Johnson, have you had a chance to look at the Bothell Municipal Code on that? I have before. I just don't have it right in front of me.
Yeah, it's 9.05.040. I would note that it notes that it's a misdemeanor, and according to the preamble of that title, it appears that misdemeanors are adopting the RCW standard for misdemeanors, but it notes for purposes of the fine. This is my quick interpretation.
Wait, you said which? Wait, it's Bothell Muni what?
Bothell Municipal Court 9.05.040. That's the crime.
Thank you.
And they mentioned that it's a misdemeanor. And at the end, it does correctly state placing a person in fear or apprehension by threat is a misdemeanor and may be punished by a fine not to exceed $1,000.
Okay.
Now, the only issue would be then was whether Bothell incorporated the RCW for criminal offenses, and that's what I was looking at. And according to Chapter 9.01, adoption of codes by reference, it notes that trying to find the right section. It's 9.01. Let me go back. 9.01.060. I'm going to make sure that's that's the section that states RCW Title 9 entitled, in quotations, Crime and Punishments Adoption by Reference. Let me make sure the language is specific in there. Let me find it.
All right. I don't know what's going on here. Alyssa's telling me that I've got 2 prior videos. I know I have 1, maybe 2. And then other people are telling me there's a lot more to this story. And this guy's giving me the heebie-jeebies. I might have to figure this out.
And looked at this, Your Honor, I don't see it included. Apologize, I'm doing this on the fly.
I
I
understand.
could tell the court that according to this, reviewing this briefly under that title, and I'm specifically talking about 9.01.060, they're adopting certain RCW sections as by reference. I don't see the 9.05 included in that, in the Bothell Municipal Code. So I can't say that there would be jail punishment. So to answer the question the court has, my review of that is I don't see punishment as jail, but there can be a fine punishment. It would still be determined a misdemeanor based on what I'm seeing here.
All right. Well, thank you for doing that. And so it looks like a standalone Muni code as opposed to a reference or an adoption of an RCW. Okay.
Regarding 2276, I'd like to point out the following. There's more of this hyperbolic statements with no facts behind them until you get right down to the bottom. It says, I just stood there, in quotes, I guess this officer's quoting me, I just stood there for over an hour to see if he'd give up. This was in regards to the alarm going off at Rios's apartment. I actually listened to the 911 records, and Pedro Rios called in twice pretending to be someone else. Then he called in claiming he was in Florida. And then his girlfriend called in claiming he was in Florida, but kind of let loose with the fact that he's probably here. And I believe this alarm has to be reset every 30 seconds. I think he was sitting on his couch setting the alarm off. So there's actually no evidence of, of any kind of threat.
Okay. Well, Mr. Ruby, here's what I'm going to do. I've read the police report. I do understand where you're coming from. What I want to do is I found probable cause. It is slim on this one. What I want to do is get a chance to hear more of your argument regarding this particular crime specifically, as well in your 8.3 motion to dismiss, which we will get to setting in just a moment. But I see where you're coming from. Okay, so here's what I'm going to do. I'm going to enter the plea of not guilty from anything that we can see. You're right. It looks like for some reason, and I've never seen this before actually, that this is a local criminal ordinance that lists it as a misdemeanor, doesn't reference anything that is similar to an RCW, and only sets a maximum penalty of $1,000, no jail time attached to it. I'm going to give the city an opportunity to that a little further. If it comes different, we'll deal with that at that time. Okay, but for right now, it does. It looks like there's no jail time attached to it.
There's 2 of these.
Okay. Well, the other ones, that's the only one that are you talking about something prior that's?
Yes.
Okay. Again, we can deal with that later. I didn't make those rulings, but we can come back to that, okay? At a different time when we're talking about this. All right. So that's 276-007 and 251. The last 2 are case 5A-016-5252. Again, another violation of a protection order, anti-harassment order. This involves the chair again, okay? Your same objection is noted. Your same reasoning is noted.
Yeah, it's ridiculous.
Okay, I get that. I get that. Okay, but again, for the level of probable cause, I did make a finding there as well. I'm an enter plea of not guilty on your behalf on that one. Okay, last one is 5A-016-5253. This is another violation of anti-harassment order. This involves some kind of a note I haven't seen. It hasn't been submitted as part of the evidence yet. I don't know if you have it in discovery. I'm not privy to the full discovery, just the probable cause statements. I do make a finding there's probable cause there as well.
Your Honor, I could just dispense with that right now. In the police report.
Your objection is noted on the PC, but go ahead.
1 second, I might as well open it up.
I can dispense with that right now.
So in the police report,
He hasn't won a thing yet, nor is he going to, but okay.
it reads some of whatever they found in there. First of all, they don't have any evidence of me doing anything, but
Yeah, yeah, right. I understand.
I'm okay.
Speculatory evidence and allegations at this point.
Well, the what they've reported in the police report starts with one of you came to my door and told me that Pedro Rios said I was playing loud music. This is not the case. And the fact is that this is protected First Amendment speech, and these court orders they're prohibited from interfering with those protected speech. Like 7.105.010 definitions, the court granting temporary protection orders or civil anti-harassment protection orders shall not prohibit respondent from exercising constitutionally protected free speech. There's nothing harassing in this, nothing at all. It's the way you read it, it's merely a response to harassment by Pedro Rios. It's actually evidence of Pedro Rios harassing me, which has been the case from the beginning. I've been the victim in all of this. It's just so the law seems determined to let somebody that continually lies get away with it. In fact, he's refused to prosecute Pedro Rios for anything he's done, and he's done much worse things. And I want to make it clear that I'm not saying that I'm not
These claims are really hard to prove, and they're really disfavored by courts for First Amendment reasons. They really are. So the argument he's making that all this protected speech and all that is not a bad argument. I don't think that this is easy to prosecute. I think you can show us a pattern of harassment and trying to do something. So so I think it's makeable as well, but this is a tough case. This is a tough case.
Complaining that I've been and he hasn't. I'm just saying that's an indication of the bias problem and misconduct. And there's other evidence of misconduct. So
okay. All right. Thank you, Mr. Rupvik. And again, these issues we'll be discussing, and I'll be ruling on these at a different time as well. So for right now, I'm going to enter a plea of not guilty on that one as well. Okay. So we've gone through all of the current cases you're on for arraignment at this time. And so what I'm going to do is I'm going to hand it over to the city first to make its conditions and bail argument. Then I'm going to hand it over to you, Mr. Rupvik, who you can call as a witness, and then I'll make my ruling. Okay. So Mr. Johnson, go ahead.
Thank you, Your Honor. As I noted before, I'm going to rely upon notes from Mr. Lohr. So I'll recommend the following to the court. It's included in the proposed pretrial release form as well. I'll state as follows that the city is requesting increase the $1,000 bail that was posed on October 8th, 2024 on each of the 6 cases charged up to that date. And I can tell the court which cases those are.
Okay, I have it plenty.
Okay.
Yeah.
City's asking to increase bail on those cases to $2,500 each. There's 6 total for violating the court's condition of no new law violations. There's a reference to another condition that's requested, not regarding bail, but Mr. Lohr indicates that there at some point when all these cases were going on early on, he noted the following. He's asking the condition be that Mr. Rupvik not ingress or egress using the stairwell in front of Pedro Rios's front door at that residence amongst those apartments or condos. Mr. Lohr indicated the following. During the months this condition was in place, there were no criminal charges filed against Mr. Rupvik or Mr. Rios. Mr. Lohr indicates that Mr. Rupvik's actions have intensified to a level they're concerned about some type of physical confrontation in the future. I don't have any personal knowledge of that. The city is concerned that this situation to some extent could be mitigated by Mr. Rupvik avoiding that stairwell. There's apparently another stairwell. Again, I don't have that information. I'm going to cut it off at there, but the court's aware of that condition request. All the other standard conditions would be requested as well for those. I don't see bail requested by Mr. Lohr for the new 4 cases. Just standard conditions, also that condition related to apparently the shared stairwell that goes in front of Mr. Rios's door. So that's the city's recommendation, Your Honor. If there's any questions you have, I'd certainly try to answer them for you, but that would be the city's request.
Okay, thank you, Mr. Johnson. I appreciate all that. So, Mr. Rutvig, would you like Ms. Ganetti to?
Yes, why don't we do that?
Okay.
To get her out, she has to be somewhere.
So, Ms. Ganetti, I understand that you need to be somewhere.
Yes, sir.
Good afternoon. You are here, my understanding, to speak in support of Mr. Rutvig regarding the court's need to consider whether to keep him out on his personal recognizance and the bail he's already posted, or to impose some additional bail based on the new cases. So go ahead, ma'am. What would you like me to know?
Oh, sure, Your Honor. I apologize. I couldn't hear prior, so I'm just going off of what I know. And what I'll share with you is this, that the situation is really frustrating because, you know, I do feel like the city and the police and, you know, the whole situation is, you know, it's maddening to Eric because he is trying very hard to use whatever tactic he can to explain that he needs protection and that these people, this person who by the way comes across as very, very delightful at times, has a slight, he's very I mean, for lack of a better way, he's just an awful person. Like, he screams vulgarities. He's very, and this Pedro Rios really has been the instigator in all of this. And I feel it's a very frustrating situation. And I don't know the reasoning behind increasing bail. It seems retaliatory. That doesn't even really make sense. I mean, this is a man who's trying his hardest to plead to you all that he needs help from the situation, and it seems like the people that are involved in the situation are just hell bent on making.
I get it. Nobody's buying this. Your client's an annoying jagoff. I don't know about Pedro. Jury's out on Pedro, but your client is hard to like. Might he stay on within the protection of the First Amendment based on this conduct? Possibly, as a matter of law, whatever. Make those arguments, but don't try to get us to like him. He's displayed himself.
It seem as though he's the culprit or the instigator, and in all of the cases I've witnessed, he is not. And in fact, I mean, he might come across as, you know, abrupt in nature, but Eric I've known Eric for, I don't know, over 15 years now, and I've done business with him, and I've never, ever, ever, I mean, I can understand that he definitely has of pace in the conversation from time to time, but any normal person could just wait it out. As far as what I just heard,
is she saying she did business with her client? Okay. Were the burritos involved? Because if there were,
say the words that she said, or
I'm just.
Sure. I need for you to tell me what went on.
That I'm not on that whole shit. I'm not with that whole shit.
About walking up the stairs. The stairs is right in front of his house. That'd be like me asking me to go walk around somebody else's house and go into the back door behind someone else's house to get to my own property.
Okay, this is just somebody else. I was wondering. I'm like, God, if she's an attorney, she's horrible. All right, she's not. She's another witness.
It just seems unreasonable to request such a thing. For somebody who is at the bottom of the stairs, has a, you know,
gotcha,
barrage
right,
of Americana and lights and videos and flags and, you know, waving loud music and screaming vulgarities from the bottom of, you know, where he's at. I don't know. It just seems like, I don't understand why the police and the people involved can't see the situation for what it's worth. And it is frustrating to Eric. It's frustrating to me. It's frustrating to everybody, I think.
You say she's just a friend?
As far as the bail is concerned, that just seems unreasonable.
Laura, why don't you tell us what you think of me as a person
Sure. Yeah. I mean, Eric has been delightfully, he's a good sound business person. He thinks things through on every level that I can think of. He's been helpful to me. I have 2 sons. I went through a divorce several years back. He was exceptional support for me.
Oh, hey
Whenever
now.
I've needed Eric as a friend to help me do something, move something,
exceptional
build something,
support.
he's always been there.
Exceptional support. You know what I'm saying? Hey.
I've never, ever, ever had any confrontation or weirdness or anything. The only times that I can say to you that, Eric might get frustrated is when he has something on his mind and he needs to say it and he wants to finish his thought. But that's about as crazy of an attitude as I've ever seen him have. He just wants to be heard. I think we all do. So I don't know what the situation is with the, unfortunately, Pedro Rios something needs to, it's like, it would be nice if they could just split up. It would be nice if Pedro could walk around his house to get in, but he can't because he is at the bottom of the stairs. So.
Okay. Thank you. I appreciate you being here and all of that. I really do. I really do.
Good.
A lot of times I have to make these decisions in a vacuum, and I don't particularly like that. I don't get a lot of corroborating evidence one way or the other. So I do appreciate you being here. Okay, so Mr. Rudvik.
Thank you, Nora.
Yeah, and again, what I'm going to do. Oh, sorry. Go ahead, ma'am.
Would it be okay if I left now?
If you want, yeah, absolutely. You use your excuse. Thank you again for being here. All right. And so, Mr. Rubik, I'm just going to warn you again. Again, this is your bail hearing, and I tell this to everybody, even if people are represented or not. You certainly can say anything you want. You have a constitutional right to speak at your bail hearing. Again, don't say anything about the underlying facts of the case for fear that you might divulge something you don't want out there because it is being recorded, can be used against you. Any comments, please, at this point, just limit it to the decision of the motion by the city to increase bail on the prior cases, or essentially exonerate the bail and increase bail at that time or at this time. So just limit it to that, but go ahead.
Well, I'm actually surprised that the city would be that nice to me. I'm shocked, actually. However, I will address the increase causes a problem. When Soto-Lor lied to the court and without my being present, he caused a situation where all the bonds needed to be reposted, and it cost me nearly $1,100. And so if you were to do it,
you picked up new charges, so now they have to decide. They're addressing bail to decide if they should, if he should have to post something because he has new charges.
That way, what you're talking about, that would probably be $1,500 or more in fees that I don't have. And normally I can earn a decent living, but this guy is such a whack job. It distracts me from my work, and it's really hampering.
Really? You're calling people a whack job? Interesting. Do tell.
So I would say, there's no need to increase bail. I'm showing up every day. I own my own house. I've lived here since 2001. Haven't had a problem until Pedro Rios moved in October 23, and he's just been harassing me every day. I have a number of things to say. Regarding, I call it walk the other way. This is a building that has 2 staircases, and there's an emergency walkway between my door and the same unit. I live on the top and the same unit on the other end, but you have to walk past other owners' bedrooms that open up onto this walkway, which is also
seems more
narrow,
like
about 30 inches. And I hesitate to leave at night because it's hollow and it makes a lot of noise, and it makes me look like a criminal. But Judge Rosano lifted that order for that reason, and the fact that I'm trying to remodel my condominium, and I need to carry tools and materials in and out. And
Yeah, that's not suspicious. I like that it makes me look like a criminal. Meanwhile, every time he opens his mouth, he makes himself look like a criminal.
What's going on here is that Pedro Rios has manipulated the police department into wanting this. Really, what Pedro Rios wants is to tell me what to do at all times. But what if you were to read, like particularly the September 3rd police report, he has this extensive surveillance system, a camera in the bedroom window, camera in the kitchen window, one in the doorway, and he uses these to alert himself to my presence. And what he does as I'm walking past is he engages in various threats. That's the problem. It's the surveillance system.
Right. So if I can interrupt for just a minute. I'm still deciding how I want to deal with that, but you're saying that the ingress and egress that the city is asking me to preclude you from, like it kind of was before, would put a undue burden on you to go around to the other one. Is that what you're telling me? For these
Yes. Well, yeah, it would interfere with my neighbors' privacies because we're
and this is a main ingress egress right now for you?
Yes, that my stair steps empty out right into my front door.
Okay.
And so,
okay.
And besides that, I own the property. I paid for that. And I've never harassed this guy anyway.
Oh, okay. I now I understand the position. And so I'm not, there's two things that I have to consider when considering whether bail is appropriate or release on PR or an increase in bail. The first is, are you going to be a flight risk, right? Are you going to show up to court or not going to show up to court? I make a finding that you are not a flight risk. You've shown up to every court, when you don't and everything. So that's not the issue. The issue is, the second part is, are you going to what's called interfere with the administration of justice? What that in these type of cases boils down to, if I release someone, you in this situation, of course, on your own personal recognizance and or the bail that you've already posted, am I assured that you are going to follow my specific orders of that release, right? Those conditions of release, including whether you agree with the underlying order or not, whether you agree with the assessment or not, whether any of that, are you
do
going
whatever you order?
Okay, that's my question. If you and I have a conversation right now saying, this is what I'm ordering, are you going to comply with that, right? Are you going to comply with that, whether you agree with it or not?
If you order it, I'll do it.
All right, knowing that the stuff you disagree with what the allegations with Mr. Rios or the cops are saying or whatever, you have the avenue of a jury trial to express it to them. But for right now, that's my concern. Are you going to follow my orders that
Of course. I've always followed the court's orders.
All right.
I will tell you this because Judge Rosano lifted this order was briefly in place. I forget why, but Judge Rosano lifted it. But the Pedro Rios that night assaulted me as I came home at 10 o'clock at night. And he was pretending to not know I could do that, but he was actually informed of it at 3 o'clock in the afternoon by Officer Moss.
Okay.
So the problem is Pedro Rios. I'm not going to create problems.
Here's what I'm going to do, Mr. Rubik. Here's what I'm going to do. And Mr. Johnson, I want to be very clear, obviously, since you're sending it on to Mr. Lohr as well. I want, anytime I either impose bail and conditions of release or do a PR and conditions of release, I like to know that the individual knows what my expectations are as the one ordering it. Okay. Now I know Judge Rosano, I believe, is the one that ordered all the prior conditions of release, and those, Mr. Rubik, stay in full force and effect on those other pretrial cases. But these cases here today, this is the first time I've imposed conditions of.
My God, I like this judge. He's a smart guy, but he's too nice. Here are my effing restrictions. If you violate them, I put you in the can. Next.
Release with you. This is the first arraignment that I've done for you. Okay. So here's what I'm going to do. Every other case that I probably ever had, somebody comes back with new allegations like this, bail is absolutely appropriate, right? Because it's clear to me, at least allegedly, that they're not following court orders. But another court had that conversation with you. Now you and I are going to have the conversation, and I like to have that with the individual so we are on the same page. So if you don't comply with it, and I find that you haven't, at least to a scintilla of evidence, then I'm saying, hey, I told you not to, you did it, at least according to this report, now there's going to be consequences. Right now, right? So we're going to start over this. So, Mr. Johnson, that's the reason right now I'm going to decline the request to exonerate the prior bonds and raise bail in those. The city isn't asking for bail in the new ones. Obviously, I'm going to go with that as well. So I'm going to keep the bonds in place, Mr. Rudvik, that you've already posted. I'm going to PR you.
I think that's probably, I don't have a problem with his reasoning or his conclusion. I probably wouldn't put bond on this either. It is kind of thin. But I would just say, here are the damn restrictions. Don't violate them.
Personal recognizance and release on all the new ones, okay? That's going to remain so long as, and again, here's where you and I are on the same page, you comply with my conditions of release. Appear on time for all your future court dates. No further criminal law violations of any kind supported by probable cause. Keep this court updated with any change of address. I know you're not moving, but that's part of it. Don't go onto the property or have any contact with Pedro Rios, okay? And abide by any of the anti-harassment or civil protection orders that are out there. And I know you had something yesterday. I don't have any of that information. What happened? That's fine. Right now, that's not relevant. If it's out there, there's some kind of protections. I'm just ordering you to follow that as well for right now. And that's it. That's it for this, okay? What I'm not going to do, Mr. Rudvik, at this moment is I'm not going to limit your ingress, egress into your apartment for right now. If there continues to be issues, man, it might be one of those where I say, hey, you got to use the back stairs because honestly, it protects Mr. Rios and it protects you, right? From these allegations, right? Walking past. Frankly, I'm not going to order it. If it was me in this situation, I would probably use the back stairway, but I'm not going to limit your ingress and egress right now. Okay. But that is going to be on my mind if other stuff comes up. Okay. Are we all very clear on my expectations if I release you?
Crystal clear.
Okay, good.
I would like to ask you to consider one thing should something happen. I've been targeted by Pedro Rios and
we've heard
the Bothell Police Department on this.
No one cares.
If he manages to get away with it again, I would ask that you consider the circumstances in my explanation.
I always
versus a scintilla of.
Well, I have to follow the law. So probable cause is one thing, but I'll make you.
Yeah, Judge, give me a perspective hypothetical ruling on whether or not it's going to be okay if I get into an assault and battery situation next Thursday. How dumb can you be? Holy shit. I would raise his bail right there. I can't take it anymore. This is why you don't want me on the bench. There would be a price for that stupid question.
Your argument, okay? For sure.
Well, if that happens, I don't want to have bail problems. So maybe you can say there's a scintilla of whatever, but you're willing to consider whatever I have
That's
to say.
it. It just went up. Every time you say scintilla, it's going up. Every single time. Just keep going.
I'm always willing to consider anything you say. Okay. I do have to follow the law then at that point, but I will absolutely consider it, of course. Now, here's the question, Mr. Rudvik. Some of these cases are on pretrial, some of these cases are on arraignment. Do you want to keep all these cases together, at least for right now? And I'm not saying what goes when at a jury can be later on. You want to keep all these cases together and give yourself a little more time for your next court date so you can, like, as you requested, go through all this stuff.
What do you mean by together? Hear them all at once, or?
Well, at least at a preliminary phase, because right now they're all set for pretrials. Pretrial is a time for you to review the evidence, for you to speak to the prosecuting attorney about possible resolution, or at least getting ready to set it down the line for a jury trial. That's normally what happens. Everything's put together. These are on different speedy trial paths, but you certainly, if you want, can put them all together on the same speedy trial path. And so when we're back again for your first pretrial on these, everything's together. And then at that point, what I would be expecting to do is set this for that 8.3 motion to dismiss that you wanted to have, right?
Well, as well as the other, both of them.
Yeah, whatever motions that you want to submit. I'm assuming those motions apply to all of these cases.
Yes.
Yeah, the first day on the bench when I wear the black robe with no shirt underneath, zipped halfway down. That'd put an end to the whole career right there.
Okay.
So sounds like you're being efficient there.
Yeah.
If the point is we go to this readiness hearing and we address these motions, to address these motions on everything at once, that's great. But I don't want all of these heard on the same trial because it's very prejudicial.
And that's a reasonable motion. We would obviously all to get together and have a hearing about that, about what cases, if any, should be joined, which should stay separated because of that specific issue, efficiency and prejudicial concerns. Right. So for right now, no, nothing's being set for jury trial at the moment. We're just setting this for the preliminary first pre-trial for these new cases and joining the other cases again, just for the pre-trial phase. Okay. Is that right?
Yes, I agree.
So here's what I'm going to do. Usually these are set about 30 days out. Do you want to set all of these cases 30 days out?
I'm not entirely sure what I need to be ready for at that hearing.
Nothing other than make sure you're ready to then set an 8-point, your motions, and then we would give a motions date with a briefing schedule. But it's kind of one of those, everybody takes a breath, everybody kind of gets a chance to look at all the evidence. And then, we go, okay, now we're here at this next court date about 30 days out. What motions are we going to set? What's the briefing schedule? Is there going to be testimonial? Are there going to be subpoenas having to set out for motions, not a jury trial, motions? Because that's what you want. You want pretrial motions. That'd be the only thing you'd have to be ready for is the next court date, the next motions date after that.
Yeah, if we're just setting the pretrial motions, then I think that's easy to do.
Okay, we're setting the next pretrial date in order to then set motions date. Okay.
Got it.
Okay, and you're good with that.
Yes.
Now let me ask you this: the speedy trial on these new cases expires on June 17th because speedy begins today on the new cases. Do you want to waive your speedy on the pretrial case, the other pretrial cases, to coincide with these new ones?
Yes.
Okay, so you're okay with me
Maybe I'll get
accepting
one.
your waiver of a speedy, setting your commencement date for the pretrials today at March 19th.
I can't do it on the bench, but I
speedy
can
now on June
do it here.
17th. Okay. Okay. So I'll accept that. Mr. Johnson, make a note of all of that. All these cases, at least for the pretrial, are consolidated.
Sorry.
All right. Who else is just dying to see Pedro? I want to know what Pedro looks like now. And anybody with a scintilla of thought has got to be thinking what I'm thinking, which is I think Pedro can kick his ass, which is why we're doing all this passive aggressive camera crap. I think this guy wants to bait Pedro into kicking his ass so that he can. It's passive aggressive. He wants to bait him into a fight and then get Pedro in trouble. That's his goal in life right now. I could be wrong. And I can't tell if Pedro, literally from what I know so far, Pedro could be like totally cool. And then he's just being, dragged through the mud by this guy, or Pedro could be independently just like this guy's kind of an a-hole. There's no two ways about it. But Pedro could also be an a-hole. And there's just two a-holes that don't get along. Or P could be innocent. I have no idea, so I got to see Pedro now. Somebody find me Pedro. Let's get him on the show.
I have no objection. That all makes sense.
Okay, thank you. Now we're going to find a date. Okay, obviously about 30 days out.
I literally had that thought as well.
That works for everybody.
Not even joking.
And again, Ms. Rubik, these pre-trials are going to be in the afternoon to accommodate your request for that under your GR 33 request.
He's awfully obsessed, and it's just not to sit there and whine like that is just not a typical masculine behavior, shall we say.
That's okay.
Thank you.
Let's see. Madam Clerk, do we have 4:21 in the afternoon via Zoom? Does that work, Madam Clerk or Mr. Clerk?
One moment, Your Honor.
I'm sorry?
One moment.
Okay, thank you. Let me make sure that I'm available too. April, did I say 21st? Okay. I have the 21st and the 28th available at the moment.
On the 21st, Your Honor, we already have 31 hearings set.
Okay. What about the next week on the 28th?
That's my guess. That's my guess. Or is it like a throuple scenario? Or they're both like going after? I don't know. There's something deeper that we're not discussing. We're not discussing the real issue here. And now I'm kind of fascinated.
On the 28th, Your Honor, we also have 31 hearings set.
Okay.
The next date we have 2:30 time, which is free. So I can block that, or I can close that calendar.
What
fit
date's
it.
that?
It's on May the 5th at 2:30.
Pretty far out.
That's a little far out, Madam Clerk.
Okay. Do we want to maybe have a start time of 1 o'clock on April 28th?
I can do that, Mr.
Or
Prosecutor.
we have a motions calendar that only has 2 set on April 29th, which is Tuesday.
And what time would that?
That time, Your Honor, is at 1:30.
Yeah.
Go ahead, Judge. I'm sorry.
Go ahead.
The 29th would be fine. That'd be a motions calendar. I think Mr. Laura should be available.
Now let me
If
check.
that works for the court.
Let me see if I'm available. Oh, okay. I'm available on April 29th. Mr. Rubik, are you available at April 29th? Madam Clerk, did you say 1 o'clock?
One moment, Your Honor.
I think it was 1:30, but I'll.
1:30, Your Honor.
Mr. Rubik, April 29th at 1:30 work for you?
That's great.
Okay. And again, this is just your first pretrial hearing on all this. At that point, we would be setting a motions hearing, and I'll be assigning a briefing schedule at that time, okay? All right, April 29th. We'll leave Speedy at June 17th for right now.
Okay.
That's for that. I've gone
Judge, sorry to interrupt.
Yeah,
I just
go
want to make sure I got the court's holding. So we're maintaining bail on the existing cases and PR with the obvious conditions the court ordered on the 4 new arraigned cases. Is that correct?
That's exactly correct.
Perfect. Thank you.
All right, now let me get back to the pretrial ones.
Okay.
Why is not letting me do that? Sorry, give me just a moment. 319, there we go. Oh. Madam Clerk, did we put all those together? I just signed an order that's not there anymore. Oh, there it is. Sorry. Okay. The 007 case is a pretrial case. It wasn't included in the other ones, but everything's going to be pretrial going forward, so we're fine there.
Right. I think it was just adding charges, so that makes sense. I'm not a fan of these electronic orders, but it's part of the new world.
You and everybody else, right? Okay, so 429 there as well. And I'm going to indicate that Mr. Rubik's requested to set commencement on those cases today. So speedy trial in all these cases is now June 17th, 2025. If you waive that later on, that's going to be your choice, Mr. Rubik. For right now, technically all these cases have to be set to go to jury trial by June 17th. Obviously, a lot of times, if you need more time to prepare or for a good cause reason, I would consider extending that. But for right now, June 17th is your speedy. Okay, do you understand that?
Yes.
Okay. This request, that's granted. All conditions remain in full force effect on those pre-trials, and bail remains, or bonds posted, I should say, maintain on that. Okay, everything's set now for April 29th, 1:30 via Zoom. Anything else, Mr. Johnson?
No, Your Honor, thank you. It looks like the orders are great. So
okay. Anything else, Mr. Rudvig? We're going to get you a copy of these orders as well.
Yeah, if you could email those, that'd be easiest.
Madam Clerk, can we accommodate that? Can we email Ms. Rudvig and send them out versus mail?
Yes, Your Honor.
All right. Yeah, we'll do that for you.
Judge, do you want me to go ahead and sign the motion to continue essentially I call them the old 4A cases. I can sign that off on that if the wants.
Yeah, that's perfectly fine too. And yeah, go ahead and sign that if it's acceptable to the city.
It is. And I don't need to sign the other order of the new one, so we're good.
No, we're good. We're good. We'll get the rest. Okay, Ms. Rubik, we're going to get you these copies as well. Again, we'll see you April 29th for your pretrial, and expect to have, we'll have some dates to set and a briefing schedule to get that motions on the docket. Okay.
All right. Thank you.
All right. Thank you. Court will be in recess. Thank you, everyone.
Thank you.
All right. All right. All right. I've learned my lesson. You have to hold the video to the bitter end. Nothing happened there. But I always cut him off too soon. That's just one of the things I do. I kind of got into that in a weird way. It needed more action. But it's interesting, and I did one on this case before, and now I'm getting deeper. Like I'm really curious about Pedro. Somebody know Pedro? Let's get Pedro, and I'll talk with Mike to talk about his side of this deal. I really want to know. Like Pedro could be like perfectly reasonable, and then this guy just hates him for that. Or Pedro could be a complete a-hole, which would also be funny. We can't lose either way. Either way, we're pulling for Pedro. You know, if Pedro's an a-hole, then that's like, you know, it's like watching two Karens get into it. You're just like, we can't lose. It's just, you know, have at it. Start a big slappy fight. If Pedro's a nice guy or a reasonable guy, then we have a different view of it. But it's still fun. That's the mystery man. I do like that judge. I do think the judge is a smart guy, but he's too damn nice. It's the culture out there. It is the culture. It's not just I knock on Washington or wherever the hell that is. It's not just the culture. It's also the times. My God. The you would occasionally get a soft judge back in the day, but I mean, 90% of the time you started with this crap and cutting off the judge and trying to talk down to him about the law. It's like, yes, you made your argument. He's ruled against you. Shut up. Even there, I wouldn't have done it big because I think this is thin. I think this is a low chance of getting a conviction. And I don't really have a problem with that. Even though he gets on my nerves, the First Amendment means that much to me. That doesn't bother me, but that doesn't mean that you don't try to prosecute as a prosecutor either. So I get the judge not being, and it's not like too crazy charges, like no big victims or anything. It's just sort of like annoyance stuff. But just for me, out of lack of respect for the court and the people that I'm there on behalf of, if you go out and pick up charges while you're on bond in my court, you're getting a raise in bond. I don't care. Just there has to be an increment. I don't care if it's $100. You got to post something now. Oh, look at that. I knocked myself out. There's my green screen. I don't know what happened. Well, there you go. There you go. See, it's a real genuine green screen I got behind me. I did this. Oh, now I'm knocked out again. I don't even know if you guys can hear me. Ooh, that connection is touchy. Let me see if I can fix this on the fly. Boom. Chicago, Chicago, that title in town. Yeah, I'm wasted. I had one what I had a high noon. This high noon was sent to me by the food fairy about 2 weeks ago. But I finished that high noon and I can't even see straight. So there you have it. That was a wild one. Thanks again, Zach. Everybody give him some love. Law Nerds Unite. Link to his channel in the description. He sent all that to me because I had to fly all the way back from New York. Boy, are my arms tired. But I got it done. And I still got to stream out. Thanks for coming out. I'll see y'all soon.